And let me welcome you as well. I'm a former Chief Judge of the United States District Court for the District of Colorado. And this program is designed to help you as journalists be able to cover cases that involve the criminal process in the district courts, the federal district courts, as effectively and thoroughly as possible. We are fortunate today to have a wonderful panel who will work in a somewhat different model. I'll explain that in just a minute, but I want to thank BJI, Justin Troe, Jeremy Fogel, and Denise Neary, as well as Charles Hall from the Administrative Office of the United States Courts for help in putting this program together. Our panelists today are seasoned in their various areas of expertise. You'll find their curriculum vitae on the pages associated with this production. And in addition, let me just give you a preview. Dan Levine, who is going to be our interrogator today, he's going to ask questions of our two very experienced district judges and appellate judges as to what happens in a criminal case. We're not talking about any particular criminal case. Instead, we're talking about all criminal cases because these concepts could be employed in any criminal case, but often are employed in high-profile cases. Dan comes with a wealth of experience. He's written stories on multiple judicial and criminal topics. He's lauded by his colleagues, and he's ready to ask the questions you would like to hear. I urge you, as we go along, to please put your comments in the chat box. We will respond either by announcing those comments or questions and having our speakers respond, or perhaps respond directly by chat. Now, our two judges. First, we have Judge Bernice Donald. She is a very experienced judge, having presided for the United States District Court for the District of Tennessee for many years, and then was appointed to serve on the Sixth Circuit Court of Appeals, one of 11 circuit courts in the federal judiciary. She has served there for an extensive period of time as well. Judge Jeremy Fogel, as many of you may know from your association with BJI or attending the very wonderful programs that are produced, is a former United States District Judge from the Northern District of California. Before that, he was a California State Judge, actually serving as a municipal judge and then as a Superior Court judge. And most recently, he has served as the director of the Federal Judicial Center, which is the education arm for all federal judges. With that in mind, I will turn this over to Dan for an exciting and informative presentation.
Thank you so much, Judge Krieger, for that very kind introduction, and to everyone at BJI for arranging this conversation and others to increase dialogue between the courts and members of the press. Before we get into it, I just want to separately encourage everybody to really use the chat function to lob in their own questions here, particularly for the journalists who are in attendance. You know, it's of course an opportunity to get thoughts from these two incredibly knowledgeable judges that we're speaking with today. But we also, I think, have many other judges and court personnel who have zoomed in from around the country, which is really just awesome. And so it's also an opportunity to kind of illuminate concerns and thoughts for that broader audience too, and further that dialogue, which I'm really excited about. And so onto the program. I thought that the best way to structure this would be kind of to follow the life of a criminal case, from pre-trial, indictment, pre-trial, through trial, through sentencing and appeal. So that's how we're gonna try to kind of move through this. But just as a framing matter to kick this off, because I think this is going to undergird a lot of the conversation here. We have a Sixth Amendment right to a fair and public trial in this country for defendants who are facing criminal charges. And we have a First Amendment, which guarantees open access to the courts. And so, judges, I wanted to ask you, how do you balance those priorities when you're on the bench? And quite frankly, is the First Amendment in a judge's mind ever really on the same playing field that the Sixth Amendment concerns are when you're managing a criminal case? Judge Donald, do you want to kick us off?
Sure. Let me, first of all, thank BJI and thank our audience for being with us today for this important topic, because we know that all of us depend on, as consumers of news and protector of rights, we all depend on these two institutions, the press and the courts, for what they bring to our understanding of the trial process. When I was listening to you, Dan, I thought, so much of the things that sort of shape the factors that influence this conversation happen before the judge publicly gets involved. And what do I mean by that? We know that in many criminal cases, there is a good bit of discussion, press, presumption, forecasting, if you will, guessing about what might happen. Sometimes there's a buzz about a case that might be coming even before it comes. And so there is a good bit of information. Sometimes people giving public comments, editorializing, before the case is ever presented for indictment and certainly indicted, and before a judge is assigned. And so those are things, of course, that judges cannot control, because it's not really a matter then. It's not an issue or a controversy or a case in the court. But once that case is indicted and it is in the system and a judge is assigned, certainly the judge is concerned with the protection and preservation of rights. And that's a real issue. The court is concerned about the First Amendments of all of the participants, the lawyers, the witnesses, the law enforcement who are involved with the case, but also concerned about certainly the judicial process, because first and foremost, the judge is concerned with those issues of public access, but also those issues about a fair trial. The judge must safeguard the rights to that fair trial process, and must control that process so that it ensures, protects, and balances all of those rights. And you mentioned the balancing function. Sometimes that can be a very delicate balance, because there are tugs going a lot of different ways. And there are rich tools in our procedures that help us perform that function with integrity and fidelity. But it is, as you observed, it is oftentimes one that is filled with tension, as the needs and pulls of the various factions are in play. But the judge has that primary function of safeguarding the free and fair and impartial trial, so that those rights under the Sixth Amendment are protected.
So, Judge Fogel, in the tugs and pulls that that Judge Donald just referenced, is the First Amendment ever going to win in that tug and pull with the Sixth Amendment?
That's a fascinating question, Dan. And let me answer it this way. So, what's unique about the justice system, and the criminal justice system in particular, is that there are some touchstones which are really pretty basic. I mean, one of them is that whatever you do in a trial, the aspiration is you want to be evidence-based. You want people to be either convicted or acquitted based on evidence, on admissible evidence, and not on public sentiment or who's popular or anything like that. And so the court has to focus on making sure that the trial is conducted in a way that it's, whatever happens, whatever the outcome of the trial is, it's based on evidence. And there's also a very high premium, as Judge Donald just said, on procedural fairness. You have to make sure that the rules of the engagement are respected, and that everybody has a chance to be heard, and everybody has a chance to weigh in with their objections and their arguments and so on. And so judges are trained. Your job is to honor those values, to conduct trials in ways that are in accordance with the rules of evidence, and only lawful evidence comes in, and the results hopefully are consistent with that. You want to make sure that people have their due process rights. So that's what you're taught. You're taught that as a lawyer, you're taught that as a judge, and as a judge, that really is your job. Your job is not, in the same core sense, your job is not to protect the First Amendment in the way that, say, the job of a journalist is to protect the First Amendment. It's not that the First Amendment doesn't matter. I mean, it's every bit as important as the other amendments, and it's, in some ways, it's the most important because it's the first one. But for a judge to develop a consciousness, well, how do I think about this in First Amendment terms, not just Sixth Amendment terms, Fifth Amendment terms, due process and so forth. How do I think about this in terms of what it looks like in terms of public access and public transparency? Judges are not, that's not how judges think day to day. I'm not being critical in saying that. I just think, your job doesn't require you to focus on getting this other stuff right. And so you don't instinctively think about, well, what about the First Amendment here? What about the fact, say you have a high profile case and there's a lot of public interest in it, and there's really value in the process being transparent and people seeing what happens in the courtroom, or knowing or understanding what happens in the courtroom. I don't think that comes naturally to judges. And I think a lot of judges are really almost afraid of dealing with the media because they're afraid that what's happening in their world, in their judicial world, is going to get misreported, or is going to get distorted, or there's going to be some kind of inaccuracy. And again, it doesn't require any malice on the part of the journalist. It's just that they're different worlds and people see things very differently. But I think, when you asked your question, I think the main point I would make to the journalists in the room, and to the judges too, is you have different priorities, and so it's harder to remember that there is this other point of view. And I've always said, and one of the best things that ever happened to me for a whole lot of reasons is that I've grown up around a lot of journalists. And so I kind of get their perspective just in social interactions, things like that, where I didn't think about it that way, but I can really see where that's an important thing.
That's really
Dan,
interesting.
If I could just say, make this comment, because I thought the way you framed the question with Judge Fogel was interesting. You said, does the First Amendment ever win out? And I would say the First Amendment always wins out. It's just that winning is not always defined as the way journalists might think about it. And there is no one bright line or one hue that defines winning. Let me give you this from my own experience. When I was a judge on the U.S. District Court, I had a very high-profile case involving a juvenile, and it was a case that involved an allegation of murder. I'm in Memphis, in a small community, so things that may not be high-profile in other areas sometimes are in smaller communities. But there was the first issue we had to decide was whether or not this person was going to be tried as a juvenile, or whether he was going to be eligible to be tried as an adult. And there are certain rights that really append to process as it relates to a juvenile in the system, and as to adults. And so I had to make that initial hearing that I could not allow to be open to everyone. There were processes in place that I had to adhere to. But once the decision was made, then of course the press could have access to a number of things, depending on how the case came out, and there are parties they could talk to still get the information that they wanted. Certainly, if the decision was this person is not going to be tried as an adult, they're going to be tried as a juvenile, then the press has that information. So the First Amendment wins that. But if the person is not going to be tried, then that, and it gives you your line or your big decision to write the story about. But I don't think there is one line that defines winning, and I believe the First Amendment always wins because it is equal to all the other amendments.
So I understand your point, certainly, Judge Donald, about quote unquote winning. So let's take it out of the kind of conceptual and maybe just go a little bit more specific, building off what your point, Judge Fogel, about how judges are trained and what they normally think about in the ordinary course versus not. There's a criminal case and the judge makes a decision that they believe is in line with the First Amendment, but a journalist may believe has strayed too far towards a denial of access or a secrecy point of view. What advice or tips would you have for that journalist to surface their concerns in the course of a proceeding, short of having to expend the resources to hire outside counsel and actually intervene in the case, which we all know is beyond the resources of a lot of newsrooms these days?
Yeah. Well, no, it's an important question. And I think, again, like with most things in life, I think if there is a better understanding of where someone else is coming from, why are they taking the position that they're taking? Why do they have that concern? And if there's curiosity both ways about something like that, then you can at least have a conversation. I think what I've seen happen, and I was a judge for a long time, and I saw the good and the bad and the ugly. I mean, what can happen sometimes is, the judge is just say, I'm not going to let the media interfere with this case. I don't want to get a reversal. I'm just going to, play this right down the line in terms of the defendant's rights or whatever rights are being protected. And I've seen journalists who just said, we want 100% access all the time. And, if you don't give us that, then you don't believe in the First Amendment. Now, I've seen people take those kinds of extreme positions. And I think what's really helpful, and what's been helpful to me in the cases I've had where I think we worked out a solution is what are you specifically concerned about here? And I'll give an example, and some folks may even be familiar with it, but I had a very high profile case in California. It's going on 20 years ago. I can't quite believe it, but it involved the method of execution in California. And it was a challenge to that. And part of the evidence gathering process was to go to San Quentin, which is the maximum security prison where the death sentences were carried out, and inspect the facility and look at what was in place there and see whether it met constitutional standards. Well, it was a critical part of the case. The prison officials did not want anybody going there, but at the very least, the only people they wanted there were the lawyers. I've got a lot of requests from the media saying, well, we want to go, we want to watch this inspection and take pictures of it. And, they couldn't broadcast it because of the federal prohibition against cameras in the courtroom, but there were other ways to get some sort of visual and written account of what happened. And so we actually ended up having a very productive conversation. And when I say we, it was me, it was the media people, and it was several different people representing the media, and the lawyers. And we brought in people from the prison and said, well, how can we make this work so that, the prison people were concerned primarily about security. The media people were concerned about transparency. They really, this is a very significant public issue. The public should know what's going on. And, you know, the lawyers and I think were primarily concerned with making sure that we had a good record, you know, that we didn't do anything that could conceivably be prejudicial. And we actually figured it out. And we worked out a situation where one reporter came as the designee of all of the media people, like a pool reporter. That person was allowed to take notes, make reports, have a still camera, take pictures, all of which we had to negotiate to a fairly fine point so that there weren't any security implications there. But, you know, we did it. It was on the evening news. And I think all of the different interests that were involved were served. I mean, something I'm telling the story because I feel good about how it turned out. But I think that what reason that it worked is we got into the why. Why are you taking the position that you're taking? What is it that is driving you here? And rather than just kind of speaking in very abstract terms. And I think that concreteness is really important.
And were those concerns aired to you? How were they brought to you? Were they in an informal letter? You know, informal conversations? How did it work?
It started with a letter, and I'm glad you asked that because it's much better than somebody, you know, running into court and trying to get an order. I got a letter that was signed. I can't remember how many journalists were involved in it, but I mean, at least one, and I think there may have been more. I got a letter saying, we have these concerns. We'd like to be part of it. I convened the lawyers and the journalists in the courtroom. We had an on-the-record conversation and say, okay, we got these concerns. Is there anything we can do about this to work it out? And then there was some homework that had to be done with the Department of Corrections to you know, get into the prison. But the point is, the letter was what allowed the journalists to be heard, for their voice to enter into the conversation. And I think it was a much more constructive, you know, granular approach than getting into, well, is the First Amendment more important than the Sixth Amendment? And I mean, as Judge Donald said, they're all really important. So it was sort of an idea to, you know, get concrete about it.
Judge Donald, let's say you get a letter from reporters who are concerned about something that's happening in a proceeding before you. What in that letter is going to make you most likely to want to engage with those concerns and take them seriously, as opposed to maybe not?
The first thing I want to know, Dan, is whether or not the journalist has engaged in conversations with the lawyers for the government, the lawyers for the defendant. I believe that the more you can talk to the parties, the lawyers, and air those concerns, and then come to some consensus on an approach, or even bring an approach to the court, the better outcome, you know, we're going to receive. And the earlier I get those, the better. When a judge is in the midst of a trial, there's so much going on. There are almost always motions from beginning to end, notwithstanding that you had a pretrial conference. And so I would encourage journalists to, in a high profile case, to talk to the lawyers on both sides, try to manifest your needs to them. And if you can come to the court having an agreed upon recommendation that does not violate those fundamental rights that we are charged with protecting, then I think your chances of succeeding and getting relief without having to go through the hurdles of filing a formal motion and going up that chain, I think they are vastly improved. And I know that. Yeah.
No, I was going to say that's really helpful. And so get in there early, number
Yes.
one. And number two, go to the lawyers and maybe you'll be able to work something out with them.
Yes.
And it also kind of feels like if either side tells you to buzz off, then you can tell the judge, hey, listen, we tried.
Yes.
And we didn't get anywhere. So that's why we're coming to you now. And it helps your credibility.
Yes,
Absolutely.
totally. No, I completely agree with that. And, you know, in fact, in the case I just described, the state's initial response was, well, we can't do it because the prison people won't agree to it. And then that led to my holding the hearing and said, well, what is specifically their objection, and how can we work with them about it? And
Right.
so, so there really was a two-step, but I think what Judge Donald said is really right.
And Dan, I want to mention one other ancillary but related point. Part of what I'm saying too is going to be in some way impacted by whether or not the parties know and trust each other. Now, I know back in the old days, I'm from the Flintstone era. So back in our day, there used to be journalists assigned to the court building. And so in the federal courts where I worked, for example, the judges knew the dedicated reporter, the prosecutors knew them, the defense attorneys who were in there all the time knew this person, and there was a trust relationship. Now, because of the environment in which we're in, few courts, as I can imagine, would have a dedicated reporter, and it may be someone that the lawyers don't know, and there may be some reticence on their part. But I think as early as you can start building that relationship, the better it is, because there are, I think, real trust concerns in the minds of most. And if I was told when I became a bankruptcy judge and this was relative to Congress, they told me, every time you go to DC, go by and see your congressperson, because you want them, go by and see them when you don't need anything, because when you do need something, you want them to already know you. And so you want to get to know the people in the courthouse before you need anything, so that you're not eyeballing them for the first time when you're wanting them to come together and agree on something.
So given that we're kind of, I don't know if I describe it as the Flintstone era that you came from. I don't know if I use those words, but the era that we're in now, and kind of the state of trust between all of these different constituencies that we're operating with. Talk a little bit and help us understand, how, okay, defendant is indicted. We're kicking off this potentially long proceeding. How does a judge think about managing the attorneys before them in the environment that we're in right now? How should journalists understand what's in the judge's mind of how they're managing both sides in front of them? And are those dynamics different depending on whether that defendant is in jail waiting for trial or is out?
Okay. I'm going to let Judge Fogel give you the large court response, and then I'm going to come back and bring up the rural.
Okay. And I'm from the Flintstone era too, so I want to. In fact, Judge Donald and I have been joined at the hip for a very long time, and we continue to be.
Yes.
But I think the answer to your question, Dan, really depends on who the judge is. I mean, there are a lot of different ways to manage a high-profile case. And I'll just cite two, and I'm not going to identify the cases because that's really not important as much as the style that the judges had. And these are both cases that were very high profile in my home state. One of them, I think the judge kind of liked the publicity that was being focused on the case, and sort of reveled in the moment in a way. And so actually was pretty passive about how they how hands-on they were in case management. It was just kind of, well, let's just, all right, we got an arraignment, we've got a plea, we've got got motions, we've got this and that. But the judge really kind of was much more laissez-faire about how the trial proceeded. The other case I think of, which was almost as high profile, was one where the judge was much more hands-on and just from day one, brought the lawyers in and saying, we need to make sure that the media frenzy or the public outcry about this, it was a really ugly case, the public outcry about this case doesn't, sweep us over. And this is at a time when California had a default of cameras in the courtroom. So, it was the exact opposite of the federal system. And so from the very beginning, the judge sat down with the lawyers and they really kind of thought through every aspect of the case. And it was how to make sure that there was adequate public access, but at the same time that the trial was conducted in accordance with the rules and that there was a clean record. But it took a lot of hands-on work by the judge to make that happen. It didn't happen in the other case. And so the experience of the two cases was, one really kind of came across as being a bit of a frenzy, much more of a like almost like a TV drama kind of thing. And the other was a pretty in some ways a very standard issue criminal trial, although the stakes were very high. It was a capital case. It was a really ugly crime. It could have spun out of control very easily, and it didn't. So, but my point is, I think that judicial involvement with counsel and sometimes with the media, but I think primarily with counsel, to say, we've got a real tiger by the tail here. We've got a really high profile case. How are we going to do this in a way that we keep it clean? And I think that's the judge's responsibility.
Yeah.
Judge Donald?
Yes, I would just say that in a high profile case, the worst thing for anyone involved, the court, the lawyers, the journalists, the chaos is the enemy in a situation like that. I think journalists want to know what are going to be the governing and guiding rules, what is going to be the limit of access, what's in bounds, what's out of bounds, because you want to be able to cover this. And I don't believe any journalist wants to try to violate the rules, circumvent the process, and jeopardize anything. I honestly believe that. And so I think if the judge sets out the rules on the front end, and when I say set out the rules, that doesn't mean that things are going to be so stiff that your ability to do your job is going to be adversely affected. But I think that in one of the high profile cases we had in this district, Western Tennessee, it was high profile because of the parties involved. There was a congressperson involved, and the first judge had the case. I believe that there was a sense of by the parties that we're not really sure what the governing rules are. Yeah, they all knew the criminal rules, but there was every day there were press conferences being given, and Dan, that if people can use the powerful tool of the press to what they believe is advantage, they're going to do that. Now, you may not allow yourself to be used, but people are looking for advantage, and so there were situations here where there were at the end of every day there were press conferences being held, statements being made, an attempt to the belief was it was an attempt to influence outcomes through media access. Something happened at some point in time that a mistrial was directed and granted rather, and then the case was retried with a different judge, who on the front end set very clearly defined and firm rules that, and I will introduce what to you will be an ugly topic, imposed some gag orders on the parties to limit the kind of thing that happened the first time with these daily summations to the public. And they were able to get through the trial process, get it over with. The outcome was favorable to the defense. There was ample coverage, but it was not excess, I guess, coverage, and the element of chaos was removed. So I know that people don't like to hear this whole notion about gag orders, because most people are like, okay, we're infringing on the First Amendment right. But as I said before, the judge has first and foremost the obligation to ensure that the trial process is fair, and the court has to do some balancing that can sometimes be difficult. And but when we do it, hopefully people understand why it's being done, and it's a reasonable exercise of judicial power.
Yeah, I think you read my mind, Judge Donald, because as you were casting daily press conferences as a negative, of course, I'm thinking to myself, then what's wrong with that? I'm hearing your point about setting out the rules in the beginning, and it actually seems to dovetail with something you said earlier, how, it's advantageous for the reporters to come and surface concerns early. It also sounds like it's really advantageous for the court to be able to set out how they're going to run this early, and that it would behoove judges and court personnel themselves to do outreach on that, particularly when they see a high profile case coming.
Oh, I could not agree more, Dan. I mean, I think planning ahead really is a positive. And part of planning ahead is working with the lawyers, and part of planning ahead is working with the media, and just saying, well, what do you need? We had a bench media committee on the Northern District when I was serving there, and I was really happy to be on it. And we had a very high profile case. It was the steroids case involving Barry Bonds, the baseball player. And it was a hugely high profile case, especially in the Bay Area. I mean, everybody wanted to see, and the media was all over it. And I think one of the things that was helpful was talking with the media ahead of time about, all right, well, what can we do here, to make, so we don't have unnecessary friction, so we don't have this atmosphere of chaos, so that you can get the information that you need. And I don't know that it was perfect, but I think it was certainly better than it would have been if there hadn't been that effort ahead of time, really trying to understand concerns ahead of time. And lawyers, I think, were on board with that too. This is a case the public's really interested in, and they want to know what the testimony is, and they want to know what people think, but we're going to do this in a way that is at least somewhat dignified. And I think it went very well, and I give the judge a lot of credit. But I also think that pre-planning had a lot to do with it.
Right. Staying in the pretrial, one more on the pretrial phase at the moment, and this is kind of in the bucket of practical guidance. I mean, particularly in federal court, a lot is done on paper. And so as reporters covering criminal cases, I'm wondering, what kinds of filings do you think can be most useful for reporters trying to get inside a criminal case that reporters, overlook? I mean, I know I personally will always go for motions in limine, for instance, because they will kind of outline a lot of the evidence that is in play that might not have surfaced yet. But I'm wondering if either of you have any thoughts on good hunting for journalists who are covering a criminal case still in the pretrial phase. Like, what should they be looking at the docket?
Well, I'll tell you, if you can look at the motion to dismiss the indictment and the response thereto, and that is certainly going to cover the essence of the case. In a criminal case, if there is a motion to dismiss, the same. I think those pretrial motions are all going to be the kinds of pleadings that are going to shape or attempt to shape the quantum of evidence and point to the direction of the trial. It's going to bring up things that that are going to be useful to you. There will be sometimes documents filed in a criminal case that it will be impossible for you to get at, and you shouldn't. And those are going to be those things that are going to be sealed, testimony of informants. And let me just say this, Dan, should there be an era where information about an informant's testimony is accidentally available in the record, a responsible journalist should not use that, because it literally puts lives at risk. And I know that as much as journalists may want the story, no one wants to jeopardize unfairly the life and the health and safety of any individual. So those motions to dismiss the indictment, motions to dismiss, and there may be others, but should and errors are made, not frequently, but they are made sometimes. And I would just ask all journalists to understand the enormity and the importance of safeguarding certain information.
Yeah. I mean, confidential informants literally could get killed if their identity comes out, and that's a very weighty responsibility. I agree with what Judge Donald is saying about pretrial motions. There's a ton of information in there. Besides the ones she mentioned, just sometimes there are discovery disputes. How much information is the defendant entitled to get? And sometimes those motions will tell you something about the case. Judge Krieger just put in the chat a motion to suppress evidence if it's somebody saying that the search and seizure were illegal or the officers acted improperly.
Yeah, that's a great one. The motion to suppress
there's
that
a
often
lot of-
that
there's a lot
often a lot of yields a lot of detail.
No, that's right. And if there's going to be expert testimony in the case, sometimes there are challenges to the qualifications of the expert or the propriety of the testimony. And that gives you an idea. The DNA, I think now is challenged less, but I mean, there's certainly there was a time when there was a question about whether that was reliable. There's been a lot of evidence, a lot of work done on various kinds of tests, fingerprints, arson investigations, things like that. And you can learn from the motions about those things if you see them as what kinds of issues are likely to arise in the case.
And forgive me for being the voice of God for a second. We're getting some questions about members of the press that work in several different jurisdictions and good ways to get information about different judges' practices. We also have a question about an order imposed by a judge to set sanctions if the lawyers speak to the press about the cases and issue a gag order. So I'd love to get your thoughts on both of those things. Thank you.
And just to give an extra beat to that last question, this is from a journalist who says they recently covered a case where the federal judge summoned a hearing to impose sanctions against the lawyers for having informed the press that one of the defendants received a pretrial diversion program.
Mm-hmm. Well, let me give Judge Donald her choice of which question she wants to take on.
Well, why don't you speak to the last question first, and I'll speak to the first question last.
All right. So now I'm confused. So you want me to?
Okay, you got to talk about the sanctions or the
sanctions and how is it appropriate that a lawyer could be sanctioned for just informing the press about that detail?
I don't know the case. I don't know the judge. I don't know the circumstances. So I have to give all of those qualifications. It's very hard for me to see how an order like that would be appropriate. Whether somebody has received diversion usually is a matter that ultimately is a matter of public record. And so to sanction somebody for disclosing it, there'd have to be a very, very compelling reason. I mean, there have to be some. It can't just be, well, because I'm the judge and because I said so. I mean, there'd have to be some element of prejudice to somebody else that would make the disclosure of that information problematic. But right offhand, I don't see it. But again, I have to give all of those qualifications because I don't know what the judge was thinking.
Yeah. So I would agree with Jeremy, and I would say that two things. Federal judges are appointed for life, but that doesn't mean that we are not accountable to the rules, and we can't just issue whimsical orders. And so, without seeing the order and understanding what is going on, I think it's hard to answer that. However, I would say this, just like judges can't issue unbounded orders, I think the press nor lawyers can just ignore judicial orders. I think there is a process where if a person is exceeding, or a judge is exceeding authority, then I think there are means of challenging that and getting clarity. On the other question about how to learn the procedures of judges in different jurisdictions, in this wonderful technological era that we exist, most judges are going to have judicial websites or judicial portals that will give the parties information on their protocols and procedures. And I think you should look at that. Usually judges are going to have pretrial orders that they've issued in prior cases that people can look at. You can also seek out information through the bar association for that area where the court is sitting, and other lawyers who practice there. It's always good to talk to them. And, for some things, if it's about a process issue, you might want to talk to the clerk of court. If there are some internal orders that may not be reflected on the website, the clerk of court, they're not going to give you inside information about the judge, but they will tell you about the local rules that the judge adheres to, and information that governs the practice in that court. So I think those are some tools that people can use to get that information, whether you're a lawyer or a journalist. There are going to be people.
Yeah, I think that's all true, and in true Flintstone fashion, I think there's something about a personal relationship too, that if you don't know the judge, but if you know a judge in that vicinity, and you have kind of an informal relationship with them, and you just get together every now and then and just have a conversation, it can be very illuminating.
Yeah.
And I think, and I've said this whenever I've done a bench media program, I think when judges and reporters can find ways to spend time together when they don't need anything, when it's not they're not covering a case, it's just really trying to get a better sense of each other's world. So why does this judge overseal, or why does this judge never talk to the press, regardless of what the question is, or reporters ask questions like that, and they're not bad questions, they're good questions.
Mm-hmm.
And just getting some insight about it. I mean, it doesn't mean that you can go file an order and file a motion the next day, but I mean, it's just getting some perspective about who the people are, because this ultimately is a system of people. And I know it takes time, but I mean, maybe you just have coffee, or maybe you have lunch or something. But I mean, some way that you get some of that nuance that we're talking about here.
And I would say that,
Definitely.
life is different now in some respects. I remember, Dan, when I first came on the bench, the admonition was for new judges is never talk to the press. Nothing good can come of it. Never talk to them. And there was no why beyond nothing good ever comes of it. And I hope that now judges are no longer being told that. But I will also say, for judges, if a judge believes that they've gotten unfairly burned, then there's going to be some reticence.
And I don't think judges are any different than anybody who has had a bad experience with the press. But I'm glad to hear that. I think that's the hope, and hopefully that's changing a little bit.
I think it's changing.
Certainly from the reporter's point of view, those informal interactions are very, very helpful, not least just helping us speak the language of the court and being able to get further in our interactions. I mean, just that helps. I wanted to get into a little bit, though, the issue, so we're in trial now. I wanted to ask a little bit about why judges are so protective of jurors, and kind of wondering whether it can ever go to whether and when it can go too far. And what I'm thinking about here is I remember covering a trial, and at the end of it, the judge turned to the jury and said, "Thank you so much for your service. Obviously now you're free to talk about the case, but you've seen a lot of reporters here, and I'm not so sure it's a good idea to engage with the media if they come asking." Was that appropriate for a judge to do, and talk about it in the context of why judges are so protective of jurors?
Well, I mean, starting at the end of your question, again, I'd want to know why the judge said that. I mean, what were they thinking when they made that comment? Whether it's just sort of a general dislike or distrust of the media, or whether there was something specific to that case. Because sometimes being a juror is kind of traumatic. In a lot of major violent crime cases, I mean, jurors even get counseling after trial, because being exposed to the facts of the case is traumatic, and courts offer that kind of remedy. So if it's a case like that, I mean, a judge might want to say, well, you don't really have to talk about what it was like to see the shots of the grisly murder or whatever it was. So there may have been a reason. That said, the reason that judges are protective of jurors is that at least during trial, that they're the triers of fact. You can't risk having them be subjected to undue pressure, to people telling them what to do, or people threatening them, or people making faces at them, or people suggesting to them that if they go a particular way in the case, that bad things will happen to them. And in high profile cases, that can happen, has happened. Juror intimidation is a thing. And so I think judges have a duty really to make sure that doesn't happen. And I think it's worth taking steps, in courts that have cameras. You don't want the cameras on the jurors, for that reason. If it's even where you don't, I mean, separate elevators, or segregating people when they move around in the courthouse. I mean, it's just a way that you have to be careful that you aren't subjecting the jurors to the kinds of pressures to make a decision one way or the other. So I think that's the core principle. After the case is over and after the jurors have been discharged, I mean, they are free to do what they want. I mean, that's what being discharged means. Again, I don't know the facts of the particular case you asked about, but I mean, I could see if I had a case, let's say it was a sex crime or something like that, where it was just really hard to be in the room, for the duration of the trial. I could see why jurors just might not want to talk about it, and the fact that they might be legally free to do so, that doesn't mean that they should feel any obligation to do it. And so I'm not sure what I would have said or how I would have said it, but I might have said, look, you've been through a lot. I mean, if you want to talk to the press, you certainly can, but there's certainly no expectation that you will. And I don't see that kind of a comment as being a anti-media. I mean, it's kind of being respectful of what the jurors have been through in the trial.
Dan, I think the jury experience and the judge's interaction with the jury throughout the trial process are factors that can influence this. Like Jeremy said, I don't know the facts of that case, and I am surprised to hear that a judge would encourage jurors not to. But you asked the question, why are judges so protective? And I think we're so protective of jurors because they are critical to the functioning of the justice system in these United States. They are ordinary citizens. They don't have, for the most part, unique training as a lawyer, although lawyers certainly can be on the jury. Many of them have no idea. They're fearful coming in. They listen to the case. They try their hardest to do a good job and be fair and impartial. And once they make a decision, they all worry about whether I've made the right decision. And I think most of us as judges will tell jurors, as long as your decision is based on the fact and the law, you made the right decision, because that's what we ask you to do, is listen to the facts, decide those facts, and apply the law that we give you. As a trial judge, I almost always went back to talk to my jury first to thank them, and to ask if they had any non-case related questions. But when I dismissed them, I would tell them, you're free to talk to anyone you choose after you're formally dismissed. Now, and then I would let the lawyers go back and talk to them. I do want to tell you about this one phenomenon I had in a high profile case because of the subject matter. It was a case where the federal government was seeking the death penalty. And because of the facts of this case and the concerns about getting a fair and impartial jury, that was the one case in my career where I used an anonymous jury. We did not let the press see any of the questionnaires. The whole jury selection process was done in the courtroom, and we didn't have any other members of the public or the press in there at that time. But an anonymous jury is very, very rare, I believe, in the federal system.
Yeah,
but the unique facts of this case, I thought, warranted that.
I'm glad you brought that up, because I wanted to ask just very quickly about anonymous juries. I mean, it's certainly understand it in circumstances where there's a public safety aspect, gang cases, you see it sometimes. I mean, I
Yes.
totally get it. There was a matter just the other day involving, and this was a civil case involving the former president, but the judge advised the jurors to address themselves anonymously by code words, and you can comment on that case or not, but I was gonna ask you, have you ever seen that before?
Not that particular thing, and I'm not going to talk about the cases involving the former president because I think that was one of our ground rules, and we could easily spend a lot of time talking about that. But this came up in some of the mob prosecutions in New York City. I mean, that John Gotti comes to mind. I mean, there was enough evidence that the people were getting intimidated. And there were even verdicts that were acquittals where there was absolutely no way to make sense of it other than the fact that the jurors were intimidated. And so this happens. And if you think that it's happening in a case that you're presiding over, you have to do something to give the jurors some form of peace, that they're not going to end up, getting spammed or, having people calling them at home or, because these are things that have happened. And in the pre-electronic era, there were people who were threatened physically. So it's real. And I think my only thing, to sort of deal with the First Amendment issues on the other side is if you do it, anonymous jury, what Judge Kaplan did in that case, or what I would do if I had a case like that. You want to, and it's another one of these cliches I keep coming back to, show your work, explain why you're doing it, really get into the detail about why you're making the order so that it isn't just judge arbitrary says you can't do this. I mean, you have to ground it in, we're making an exception to the normal rules because these things have happened. And we have these facts and circumstances to deal with. So yeah.
Dan, could I have one other comment about jurors while we're on there? And this relates to a question in the chat. I think the question was, have you ever polled a jury and found that there was some juror who disagreed with the verdict? My habit and custom was, after the verdict was returned, to poll each and every juror to ask if this is your verdict. And they would answer. And so I've never had the situation that the questioner alluded to, but I have had a situation where the jury was unable to come to a unanimous verdict. And I had to declare a mistrial. There was a situation where there was a jury that had an imbalance in a criminal case. And after the case was mistried, one of the jurors let me know that this juror felt so oppressed by the overwhelming vote against her that she found it difficult to adhere to her singular vote. But she did in the final analysis, and she wanted basically me to tell her that you did right or whatever. And all I could tell her was the instruction I gave in the jury, that each of you must make your verdict, cast your vote based on the evidence and the law that I have applied to you. Because if we allow that system to be perverted, then we're not doing justice to the whole trial system. Every juror's vote is supposed to count the same as every other juror. And of course, if the jurors don't have a unanimous verdict in a criminal trial, except for, I think it's now one state, then you have a mistrial. There were a couple of states until a couple of years ago who would accept a non-unanimous verdict in a criminal case. And I believe now that the number of states have been reduced to one.
Yeah,
right.
But
right.
if you put too much pressure on somebody, if the holdout is for an acquittal when everybody else is for guilty, that's like basically an automatic reversal. I mean, if there's evidence that the judge has done that, I have never had the situation where a jury during polling said, no, I didn't agree. I did have a situation where I had an 11-1 mistrial in a criminal case, and the during my meeting with the jury in the courtroom to say, well, is it worth sending him back? Is there any further benefit to them continuing to deliberate? One of the jurors said, this is open and shut. This guy, I forget what epithet was used about this holdout juror, but I mean, this person is just refusing to deal with us and is completely off his rocker, and expressed that opinion. And at which point I just said, well, okay, we have a mistrial here, but had I done anything else, say, what, looked at this particular juror, said, what's your problem, dude? It's like, if I had done that, and there'd been a conviction, it would have been bounced back, as soon as the Court of Appeal got it. So it's, you just got to respect.
Yeah.
The,
and I just want to clarify
yeah.
that mine was a situation where there was an 11-1 vote for guilt and there was a 1 holdout. And after I declared the mistrial is when I gained this information, certainly not before the final verdict had been rendered.
There's a question in the chat that I wanted to hit, which is, what are some topics that court clerks might be able to talk to reporters about during a trial, which I think is a really important question. And there's a couple examples that she asked, one of them being jury deliberation emails. Like, is it appropriate for a clerk to share those? And can I just say, from my own personal experience, how frustrating it is as a reporter covering a trial to find out hours after the fact that the parties have been in to court talking about some sort of communication from the jury that was not communicated to the press, and that we couldn't be in there to hear it, because the whole trial, all we want to know is what this jury is thinking. And those notes coming out of that room are some indication of where they might be. And so I think that's a really, really good one to address. Can you say it is appropriate for courts to share that with the press and that they should do it, please? Please.
Well, I'll just say that, as I'll answer this the way we started, and that is that it's the judge's role to manage the trial, and oftentimes on jury notes, what I have gotten for the most part are things about, can we have a read back of certain testimony? Questions about, I guess, whether or not we can see the jury instruction. Can we hear, a certain piece of evidence again? They used to ask, can we see the exhibits? But we started sending all of the exhibits back there, unless it was contraband or weapons. And I don't think we file those notes with the clerk immediately, but when the trial is over, I think I would file because I would send the notes back. The question I would get, I would have it typed up, and I would send back a written answer to that question. It was, nothing all that involved, but once the trial was over, those notes would be filed. Of course, like you said, that doesn't help you then, because the trial is over and they have the verdict.
Right.
And
just what you just said, asking for a read back, is going to signal what they're focusing on. If they've been out for 2 days and they ask for a read back from witness X, I mean, that's communicating information that might be, interesting for readers.
So, this is a good question, Dan, and I want to go back to where I started, like in the beginning, when you're trying to square your Sixth Amendment and Fifth Amendment obligations with the First Amendment, right? And so, to me, this is not a question that has the same answer every time. I guess, if it was somebody asking for readback and the reporters are right there, the readback's going to happen in the courtroom. Hey, we're having readback, come on in. It's like, but I'd always want to run that through counsel. Is there any reason why this shouldn't be transparent? And is there any prejudice to this being transparent? It's hard to see with readback where it would. And some of the questions that come out of the jury room, it's hard to see what the prejudice is. But I mean, that's the question: is there prejudice? But I mean, I remember it was one of the first trials I ever did, way back when I was a Muni Court judge, and it was a drunk driving case, and the defendant had priors, but of course the jury didn't know that, and they weren't supposed to know that. And there was a question that came out from the jury saying, does the defendant have priors? Right? Well, I mean, I had to say, I can't answer that question. It's not a proper question, but that's not a situation where I would have wanted to, go on the record in the courtroom and have the press there, because it was legally irrelevant and actually prejudicial. So I think I'd want to have the conversation with the lawyers before just uniformly opening it up. But I think your basic point is a good one.
So just to be fair, the courts that I know that have handled it well, in my experience, it kind of goes back to the earlier points about establishing the relationship and outreach. There would be like an email list that already existed that the clerk was managing and would send out bulletins and say, hey, jury question in 2 minutes. And if the reporter wasn't there, hey, the reporter, right? But like the notice at least went out. And it's even in the example that you gave, Judge Fogel, I think that would still be of interest to reporters, knowing that that's where jurors were. And I'm not sure why it would have to be off the record, but anyways,
we can talk about that.
Yeah, exactly. We're burning through our time here, and it's a lot of fun. There's one question that I definitely wanted to ask you guys, which is, what is the most aggravating thing a journalist has ever done in your courtroom during a trial?
Good question. I'm a small town person, so I don't think, for me, it's I think one time early on in my career, and I don't know whether this was just whether the journalist was new or whether they knew that I was new and didn't think that I might catch it. But when we got ready to do a sidebar, the journalist sort of came forward, and I had to, just to respectfully tell them this was a sidebar and only the parties could be there. And when I did that, the journalist immediately went back behind the bar. But in an interest of trying to cover everything, I just wanted to approach and join the conversation. And I can understand the interest, but there's a reason it's a sidebar. So that was it.
Yeah, that was one of the reasons why I tried to limit sidebars, because I think that it's just, for the very reasons your comment suggests. I have two answers to your question, Dan. One was sort of a modern one where we're just we had a rule in our district that you could bring electronic devices into the courtroom to take notes, but you had to turn off the thing that made them click, and would have reporters whose iPads were clicking during testimony, which they knew that they shouldn't have done that and had to call it out. So that was just a minor irritation. Probably the thing that has stuck with me the longest involved another high profile case I had where the case was over, but there were still appeals possible and so on. And I got a call from a journalist who said, why did this go this way or that way? And I said, I can't talk to you. I took your phone call, but I can't talk to you about the case because the case is still pending, and there's a code of conduct which prohibits me from commenting. And then the next day I saw and it was a reporter I didn't know. And the next day I saw a story in the newspaper this reporter worked for saying the judge claimed that he couldn't talk about the case because of for ethical reasons or something. But it was just the way that it was spun. I was so irritated.
Yeah, the word claimed there is great.
Yeah. I mean, it just was like it totally missed the point of the conversation. And I had explained it. It's not that I don't want to talk to you, it's that I can't talk to you, And so I don't think too many journalists are completely ignorant of the ethical considerations, but some are. And I think that can be trying.
Dan, I wanted to, I know that I'm not one of the questioners, but I wanted to ask you, you said you're aware that, that anytime there's an issue of public safety, you respect the judges' obligations there to sort of exercise a balance and weight sort of in favor of public safety. It's not your words exactly, but I wanted to ask you from a journalist perspective, in situations where there is potentially undue, or in my word, undue embarrassment that might come from having information that's presented to the court on a motion in limine, and the court might impose some restraints there in terms of limiting access there when the court is making that decision, because once the information is out there, it's out there. You can't unring it. But how do you feel about judges limiting access when there is unnecessary, undue potential embarrassment that may or may not be germane to, well, not germane to the issues?
I shouldn't let you tear in the tables like this, but I'll answer it briefly, and I'll take a page out of your book. It depends. I think any journalist, if it involves a minor, if it involves like medical issues with somebody, particularly a minor, is going to be much more understanding and sympathetic to maybe the needs to keep something secret. I mean, I've never had a problem with redacting social security numbers or personal identifying information. So I'm not so much of an absolutist that I can't recognize those types of situations. I think, though, that the word embarrassment very, very, very quickly can slide to cover a lot of things which are not appropriately sealed or secret. I mean, it's often in the civil context, but also in the criminal context. I mean, we have a public system. And, if somebody, committed conduct and it's in a court filing, I mean, the default is we see it unless there is, a clearly stated, compelling reason. And just quote unquote embarrassment is not one of them. It just isn't.
Yeah.
Well, and Dan,
I was thinking about rape, some of the issues around rape victims.
Sex cases.
Of course. I mean, of course, those types of situations. But my point is that term embarrassment is often used to apply to a wide range of behavior.
I just want to say, Dan, I agree with you 100%. I think it's way too broad. I mean, I think the point that Judge Donald made is well taken. I think there's times when just decency kind of means you should be discreet in what you say and how much detail you get into. But I think embarrassment, I mean, a lot of things are embarrassing. There's a case in California, it involved Clint Eastwood, as a matter of fact, in one of his earlier marriages, where they wanted their marriage proceeding to be closed. They wanted the courtroom closed because there was a lot of embarrassing stuff that came out in the trial. And there's a California Supreme Court case that says, no, you can't do that. It's a public proceeding. It doesn't have to be that way. I mean, there are countries. One of the countries I've worked at for some time is Uzbekistan, which is a very different place, and most of their civil proceedings are closed, and the reason that they give is for the privacy of the parties. I mean, it's just a different way of looking at the world. And they just figure that it's not something that ought to be out in public. So but I think in our system, you're right. I can't quarrel with you.
And just to give you another example, Judge Donald, I mean, I've seen instances of judges sealing letters written on behalf of a defendant arguing for a lenient sentence during sentencing to protect those people writing the letters from the potential embarrassment of coming out publicly on that person's behalf. I mean, to me, that's just crazy. I mean, so anyways. We're almost out of time here. I guess I would just very, very quickly, out of our wonderful wide-ranging conversation, is there any one thing you would most like our audience members to keep in mind?
I would just say respect the courts, respect the important work that you do, and just do your job. And when we make tough decisions, continue to do your job.
And I second that. I just think, we want to work. I mean, we're not the same. and sometimes our interests are in tension. But I think to the extent that we can collaborate, we can be transparent, we can be respectful, as Judge Donald just said. That's the key. I think it's about relationships and it's about respect. And if we do that, I think we'll avoid a lot of unnecessary problems.
Thank you so much. That was great.
So on behalf of BJI, I want to thank all of our faculty. I misspelled yabba dabba doo in the chat, but it was a yabba dabba doo kind of Flintstone experience. Want to thank too my colleague Justin and Judge Marcia Krieger and Charlie Hall for all of this. This is not the end of this particular conversation, and we hope you'll join Berkeley Judicial and all of us for future programs. Thank you so much.
Bye, everybody. Be well.
Bye.
Bye.